There is a no driving affidavit on file as of March 28th where I ordered him not to drive. Just because you think you can drive doesn't give you the right to just go start driving in violation of a court order. You come here, you ask for permission, and then we give you permission. You don't just go do something and ask for forgiveness after the fact.
It's told by pretrial services.
I don't give a damn who Jesus tells him.
Judge, you don't.
Doesn't matter. A court order is a damn court order. Just because pretrial services just tells you something doesn't. Really?
Judge, you told him not to drive. The allegation is that he was driving. First of all, Judge, I want to speak on when you told him not to drive, it was because the state told you that he had an ALR suspension. What I've got for you, Judge, I couldn't access it at the time because I don't have access to our closed file. This is an ALR dismissal order.
No. Okay.
There was never a suspension on his license at all. He's been good to drive.
He was also drinking. But the concern was that he was drinking.
But Judge, you told him before you left that that you were doing this because there was already a suspension on his license that he couldn't drive. I never got the impression that you were taking that action because he was drinking.
He was drinking allegedly, and
Yes.
the license was suspended.
Yes.
Can you run his license, please, state?
Your Honor, this should be eligible.
Did it just become eligible, or when was it eligible? You know what? Let's do this. I have a line of people. I've got arraignments. Let me put this off a little bit because this is going to take a
I
lot
have
more
to go to the
time.
doctor's office. I sent you an email on Friday when you said this. I'm supposed to be at the doctor. I took today off, but I never got a response then when I asked to move this to tomorrow. So I've got to get it done. I've got to be at the doctor.
So we can do it tomorrow. You want to do tomorrow?
I'm already
Let me
here,
look at
Judge.
what,
I'm already here.
Your Honor, it looks like it was lifted on 4/2/2025.
what day was it lifted?
4/2/2025, from what I can see on the license. NCIC.
And what are the days that he's alleged to be driving?
The second, Judge, let me double check.
And does he have an interlock as well?
Yes, Judge, he has interlock. He was alleged to be driving on the second and the third.
Furthermore, Judge, the bond conditions that you signed on the 28th, nothing on those bond conditions says he can't drive. And my client tells me that when he went to pretrial services, he was told repeatedly, because he asked repeatedly, if he could drive. And so I think pretrial has the apparent authority to tell him what the bond conditions are, especially for somebody, a lay person who, when he goes there, he doesn't.
There is a no driving affidavit on file as of March 28th where I ordered him not to drive. Just because you think you can drive doesn't give you the right to just go start driving in violation of a court order. You come here, you ask for permission, and then we give you permission. You don't just go do something and ask for forgiveness after the fact.
It's told by pretrial services.
I don't give a damn who Jesus tells him.
Judge, you don't.
Doesn't matter. A court order is a damn court order. Just because pretrial services just tells you something doesn't. Really? Is that what it's now come to?
This was all premised on wrong information that he couldn't drive. He can drive. There's nothing wrong with this license. There was no ALR suspension ever. The state told you that. That's why you
It
said
was a suspension
it was
and
not
it
an
was
ALR suspension,
lifted
Judge.
on.
4/2, Your Honor.
There was no ALR suspension. I got the case dismissed. It's not possible. I mean, would you like to see the email or the dismissal ordinance from jurisdiction? Because it's right here.
Dude, I'm just looking at the records.
That's fine. I'm showing
The
you.
order suspension, it was begin date 1/3/2025, lift date 4/2/2025.
It's not possible because it was dismissed with prejudice.
Yeah, 12/6/2024, end
Herrera?
date 6/3/2025, and the lift date comes in at.
And then if that,
I'm not saying you're wrong, what I'm saying is, based on what I can see, is what I can see.
if there's a dismissal order, then that suspension is contrary to law and it's void.
I'm going on what DPS says. I don't have access to what you have. I don't know. All I know is please, you don't need to put your computer. All I'm saying is that regardless, Mr. Johnson, our court order is a court
I
order.
understand.
You don't just do something willy-nilly because you think that you're in the right because of this. No. We have court orders for a reason. If you ever do this again, I will have a contempt hearing. I'm warning you now. And the next time you do something contrary to anything, I'm going to throw you in jail so fast, your head's be spinning as fast as a wheel. Now, you have a CDL, am I right?
Class A license, Judge.
I'm not going to put you in jail now, but I want to make sure that you're not drinking. So does he have a scram on right now?
Yes, Judge.
Okay. Everything's operational?
Yes, Judge.
Don't do it again. The only reason I'm not taking you into custody now is because your license was valid on the 2nd and 3rd. Otherwise, you would be staying with me. Don't violate a court order. We tell you what to do, not pre-trial, not anyone else. Do you understand?
Sir.
All right. Good luck, sir.
Thank you, Judge.
Good luck with your appointment, Mr. Judge.
Thank you, Judge.
Counsel,
Judge, just to be clear, is he permitted to drive now?
as long as he has the interlock, he's got a valid license, and he has insurance, yes.
Does the affidavit need to be?
Yeah, we'll rescind it. Don't. The worst possible thing you could do now is drink. If you drink, you're gonna freaking lose it. Do you understand? Or put anything in your body that has alcohol in it. Don't.
If you're finding this story captivating, make sure to hit that like button and subscribe to our channel for more gripping true crime content. Your support means a lot. Thank you.
Judge, this is a plea. It was a felony case. We refiled it as a misdemeanor.
Okay.
And there is a victim impact statement. The victim is not present. So I was wondering what the court wanted to do.
I want to do it. If they want to make a victim impact statement, then I want them here and we'll do it all together at the same time. Because I want that person heard as well. It's only fair. So,
They were unable to make it today. They had notice about today's court date.
fine, we'll set it for whatever day you want. Do you want to reach out to them to see what day is good for them and then we can do it? I mean, take your time. There's no rush.
Judge,
Really.
if I may, this case is 3 years old. We've had 7 trial settings. We finally resolved it to today, and then she can't come on the day of trial.
I don't know, Joe. I'm
But
just.
that's what I'm saying. I'm letting the court know. I think that's kind of unfair to
See
my
if they can
client.
Zoom, because I have Zoom.
We could ask her. I don't know if she has that ability.
You want to see? Can we stand down for a bit?
I'm sorry?
Can we
Just-
stand down to see if she's available to
She
Zoom?
is okay with someone from our office reading it in her place, if the court's okay with that.
It's the whole purpose. No? Can you reach out to her real quick and just see? I know you're in the home stretch, Jim. I mean, I know you've gotten a great deal here. They're reducing it to a misdemeanor, getting on it deferred. So just give me 5 minutes. Let me see if they can do that.
Yes, sir.
So,
Oh, hello. Can you hear me?
yes, I can hear you.
Okay.
Okay, give me 1 second, ma'am. Give me 1 second. So procedurally, with this case, Joe, he gets charged with a sexual assault upstairs, or he's on bond for a sexual assault,
Come on.
and then he picks up an indecent.
No. Plea bargain down to a Class A indecent assault.
The felony court does not do misdemeanor probations, so we had to refile it as a misdemeanor. That's what the plea deal was, essentially.
So it was a reduction to a misdemeanor,
Correct.
indecent assault,
Correct.
to a 2-year defer.
Correct.
Okay. So let's do ma'am, what I was going to do is do the plea first and then have you say something after the fact, if that's okay. Are you okay with that?
Only if it's not allowed for me to speak first prior to the plea, then of course, yes, it's okay to speak
If you want to
afterwards.
speak first, then you're welcome to. Is there
Okay.
something that you wanted to say?
Well, I wanted to read my victim impact statement.
Please do. You're welcome to do it.
Okay, thank you. Okay, so I'm writing this statement to share how this experience has continued to affect me long after that night. There may be times where I actually need to take a moment to breathe, actually. Just wanted to go ahead and say that first. When I first submitted this statement, I was overwhelmed. I was still in emotional shock and unsure of what to say and how to say it. I've since come to understand the importance of expressing clearly, not just what happened, but how it impacted every part of my life. This event has completely changed me. I wake up with anxiety. I experience episodes of fear, confusion as to why I did not run, and constantly feel a loss of trust, not just in people, but in places I once felt safe and in myself. Every day I'm reminded of what I've lost. I lost peace of mind. I lost the ability to work without panic, the ease of everyday interactions. Every day I'm reminded of how I got taken advantage of and didn't react as I felt I would have in a moment like this. If this emotional toll has affected my professional life, my relationships, my physical well-being, I can't control my heart rates in these moments of panic. There are true anxiety, full-on panic attacks that I experience still to this day, 2 years later. At the time of my first statement, I didn't have access to important documents, which are records that might have helped me explain myself more clearly within these 2 years. Since then, I've started the process of requesting my full case file from multiple agencies, medical records, and forensic testing. I have not received those as of today just yet, but I know those documents all exist. It's been over 2 years, and this case has been reset multiple times. A new prosecutor was also assigned only days before this plea was suddenly brought to me. The rapid timeline did not allow me to revise my statement or consult with anyone about how this offer would impact my rights as a survivor or my potential ability to seek justice outside of this criminal court. This statement is not about vengeance. It's about the truth. It's about my healing. It's about ensuring my voice is heard in a process that often feels designed to just move forward without it. Every day since this assault, I've struggled with anxiety, flashbacks, and trust issues that have reshaped how I live my daily life. I still cry regularly from this incident. I still shut down. I still replay everything from the pressure, the coercion, the force, the aftermath of where I try to survive it all without falling apart. And yet I still feel like I have to justify why it broke me. This wasn't just a violation of my body. It shattered my trust, my sleep, my ability to feel safe in my own skin. I've spent nights replaying what happened, and the fear and the disgust and the betrayal. What was taken from me was not just physical, it was psychological and it was spiritual. I'm a hairstylist, and my career is built on one-on-one trust with my clients. Since this happened, I felt constantly on edge with male clients. I find myself backing away from simple interactions. I've lost my income. I've lost my confidence and my own safety in my own body. The job I once had, I lost due to being completely disconnected from my mind and my body. I now know that this man was on deferred adjudication and had a breathalyzer in that car, and yet that night he took his mother's car and drank heavily and violated me when I was in and out of consciousness. The defendant slapped my face during intercourse and violated me. His third time assaulting me that same exact night without consent. I remember him begging me again and again, and I kept saying no. But I couldn't get up. I pushed him away off of me again and again. That is not consent. Me freezing up was fear. That was survival mode that I was going into. And Your Honor, I ask that you consider what kind of system lets someone walk away with that and just probation. Even after all of this, I still had to let him drive me home the next day and bought me a Plan B pill. The defense says I had chances to leave, but how do you leave when your body and your brain have been hijacked by fear? The prosecutor told me that juries don't like women and that they don't believe us, and that broke me more than anything. I was told I could be blamed at trial for going to the bar or for texting him afterwards, as if trauma survivors don't respond in ways that help them stay alive. That's why I'm asking you now to please understand that this proposed plea is not justice.
Then I'm not going to take it. I'm not taking it, Justice. I'm not doing it.
Thank you for joining us in uncovering the chilling details of this case. If this story has left you disturbed or reflective, please share your thoughts and reflections. Remember to like, subscribe, and stay with us as we continue to explore the stories that reveal the darkest sides of human behavior. Together, we keep these lessons alive, ensuring the voices of victims are never forgotten. Thanks for watching. Please subscribe or follow.